Thank you very much. Carl and I are both honored to be here, and thanks for showing up after lunch, because I know it gets a little tough at this portion of the conference. We'll start off with a couple of advisory comments. One is this is a very interactive presentation, so we don't just simply receive your questions and comments. We really do crave your questions and comments, so do not hold back. Ask away at any point in time. This program actually doesn't really work very well if we don't get a lot of discussion and interaction. We're going to have 3 scenarios that we will be talking about. One scenario will actually be put on by 3 courageous actors here in the audience. They'll come up and we will quiz them as their characters. So again, you are fully invited to ask the 3 actors as their characters what their motivation was, or as one person said this morning, what were you thinking? And then we will have 2 additional scenarios, which are videos, and we'll have a discussion of those videos. In terms of the objectives, we'd like to have you walk away with some familiarity with some of the codes of conduct. In your handout, which please keep it close, you have got the Minnesota Code of Ethics for Court Employees. You should have the National Association for Court Management, the NACM Code for Court Professionals, and you should have the American Judicature Society Code for Non-Judicial Employees, so the AJS Code. So you should have those 3 for reference. We have some ethic codes that we think apply to the various scenarios that you will be seeing. But, I mean, it's our guess. Your guess is as good as ours, so take a look at those handouts. And if at some point in time you say, hey, Pete, you didn't even mention Canon 4, have at it and tell us about what was Canon 4 and why you think that it applies to whatever scenario that we're talking about at the time. We hope you'll walk away with an understanding that the codes are important. Carl and I think so, but then we're sort of ethics geeks. We will discuss the practical implications. And then we hope you'll walk away with an idea of making codes more relevant to yourself and to your court. Probably one of our nightmare scenarios about 10 years ago at a NACM national conference. I had to sit at the, I don't know what they call it, the fact table. You know, on Wednesday, all the vendors and then various courts had little tables, and I was sitting there as Mr. Ethics, and somebody came up and said, oh, ethics, we did that last year. Well, I'm kind of hoping that you'll never end up saying, we did ethics last year. Okay? Always want to keep ethics at some point in time in the back of your mind. Lastly, of course, Carl and I always have fun when we do this. We hope you also have fun too. With that, I'm going to turn it over to Carl, because I'm going to be pulling up 2 videos for us to watch. These videos are separated by their little short film clips. The 2 films are 50 years apart, and what we'd like to do is use this as a basis for some discussion as to whether the public's perception of the courts has changed over the last 50 years. So, Carl?
Thank you. The first clip is from To Kill a Mockingbird, and a lot of us have probably seen this in high school or college English classes. If you remember, Harper Lee wrote this in 1960. They made this movie with Gregory Peck in 1962. It's a movie about, and a book about a wrongly accused defendant. Black guy accused of raping a white woman. There are a lot of subplots, a lot of twists of the story, but this presents the closing argument by Gregory Peck at the end of the trial.
In this country, our courts are the great levelers. In our courts, all men are created equal. I'm no idealist to believe firmly in the integrity of our courts and of our jury system. That's no ideal to me. That is a living, working reality. Now, I am confident that you gentlemen will review without passion the evidence that you have heard, come to a decision, and restore this man to his family. In the name of God, do your duty.
I don't want to blow the contrast too much by talking too much between these two, but just to give you a lead into the second one. The second one is a clip from a movie called Lincoln Lawyer. It came out last year. Some of you might remember it. Starring Matthew McConaughey. It's a film adaptation of a book by Michael Connelly about a criminal defense attorney. Moral ambiguities, moral difficulties. You might remember, those of you who saw it, the premise of this one is he represented a prior defendant, sort of pressured the defendant into accepting a plea deal to avoid the death sentence, and now that defendant's in prison for life. Things arise where he's not so sure that that defendant is guilty any longer, and begins to question what he did in the last time and what he's doing with the current second murder with another defendant.
Roberto, ¿qué tal, señor? You mind checking that list, seeing where my man Harold Casey is on it? Oh, don't go that low. I got a Casey across town at noon I gotta get to. You mind just bringing him down? It'll only be a second.
Reynaldo.
Pardon me?
My name's Reynaldo, not Roberto. Us bailiffs all look alike, right? Your man white?
Yeah, he's white.
I got blacks down here right now.
All right, listen. Ronaldo, my bad on your name. All right, I took a wild ass guess. I was wrong. All right, but I didn't forget you at Christmas time, did I? Remember that jar of nuts with the prize inside? Happy holidays, your friend Mick?
I went through those pretty fast.
All right, let's make it 2 this time.
Okay. I'll bring your body down, but you better make it quick.
Gracias, Ronaldo.
Harold Casey. Yeah, bring him down.
Harold, you shouldn't be running from your lawyer. It's bad form. And you know what I want to talk about? In a minute, Judge Powell's going to call us down. He's going to want to know if we're ready for trial.
We are?
We are not. And you know why not. Rule 1, I get paid or I don't work.
Don't worry, I got your money.
Exactly, you got it. I don't.
It's coming. Talk to my boys.
Listen, Harold, I looked on the list of people I trust. You're not on it.
The law says you can't just quit. The judge won't let you. I looked it up.
Pay close attention. Michael Holler for the defense, Your Honor. If I may, I'd like to carry this over.
Do you have a reason, Mr. Holler?
Having trouble locating a witness, Your Honor. An indispensable witness, a Mr. Green.
How much time do you need?
That's hard to say.
Does the state object?
No, Your Honor.
All right, I'm going to hold this over pending notification from counsel.
Thanks. I love those two clips. You get drastic, lofty idealism on the one hand, and in this second clip, I would imagine it feels a lot more like a day at the office lately. What, fortunately or unfortunately, a lot more courts feel like lately. In this session, we want to concentrate on a number of different things. One of the things that I think these two clips illustrate is how our impressions, how our understandings, how the media and Hollywood's view of the courts have changed over the years. With To Kill a Mockingbird, one of the themes, you can remember from our lit classes in high school or college, you remember hypocrisy and moral ambiguity is a big one in the first one. Moral ambiguity is a big one in the second one. So I wonder if that if that idealism that you saw in the first is carried through. You think it's still there, or has it eroded despite all our efforts? Erosion? You think it's still there? Oh, cool. Because sometimes we go to these conferences and we're all about innovation and cutting edge and active and public outreach and all that stuff, and we're so busy. And a lot of the sessions this conference have talked about how frantically or intensely busy we are trying to reach the public and instill, I hate this phrase, but I'll use it anyway for lack of anything else, public trust and confidence. And we do all that with such intense determination. And sometimes I wonder whether all that work is making any progress and whether the public's trust and confidence has really eroded. Let me take just a brief detour because I think it's a valuable detour. Things to keep in mind as we go through the next hour and a half. Peter and I are working on an article for Future Trends. The National Center for State Courts publishes a Future Trends booklet every year on what the cutting edge is, what they see on the horizon, what's coming up next. Peter and I have done this a long time. Peter started writing, I think, the column on ethics in '94, and I joined him a few years later. And some of the stuff, frankly, gets tired. The discussions about courthouse gift policies, do you accept the Christmas cookies or not? I mean, that's a valid issue, and it still comes up, and it triggers a lot of engaging discussion, a lot of strong feelings. I'm not saying it's a boring issue. I'm just saying it's been around for a long, long time. And so those of us who do ethics a lot, the ethics geeks, we sort of get jaded and think there's nothing new under the sun, and here we go again with a Christmas cookie debate. I think remarkably, in a really exciting way, there are 4 areas that we've identified recently that sort of breathe new life in these ethical discussions and what we expect from court employees. One of them is a clear generational shift. And I would imagine many of you might agree with me that there's a different set of expectations with younger employees now about, for example, how much can we tell them about what they can do after 5 o'clock? In South Dakota, we approve every outside employment request. More and more, we're getting the reaction that, well, you don't pay me for 24 hours, you don't own me for 24 hours. So that the expectations, the generational shift in employees is one exciting new area, I think, for good or for bad. Another one is social media. I mean, we all know that's a hot topic. I tend to think social media tends to be more a boundary issue. Employees used to go to bars or wherever employees gather after 5 o'clock, and they used to talk about judges and they used to talk about attorneys, and we were unaware of it. The difference now, I think, is that we are aware of it because the technology is out there for them to publish what was previously unheard to the world immediately. So when I say social media with court employees, I don't know that their behavior has changed so much, but the technology dramatically changes the publication. And because we know about it now, we have to react to it now. A little later, we'll talk about whether that's really a technology issue or an ethical issue. If their underlying behavior hasn't changed, does that make it a technology issue now? I'm not sure. But to me, that's one more pretty exciting cutting-edge issue in ethics for court employees. A third one is, I think, identity. Peter and I have talked a lot about this in sort of a military context or a law enforcement context. A Marine, for example, is always a Marine, 24/7. They never have any debates about whether they're still a Marine after 5 o'clock. They have an identity. I think court employees or courts had a stronger sense of that separate identity previously than they do now. I think that's eroding a little bit. I'm not sure why. Maybe economics, maybe generational. Some of these new horizons tend to overlap a little. But I think one of the things to keep in mind or think through as we go through the next hour and a half is that idea of identity. Am I a court employee 24/7, or am I a court employee from 8 to 5, and it's really none of your business what I post on Facebook or what I do for a second job after 5 o'clock? And then lastly, I think there's some really good, healthy discussions, maybe cynical, maybe a little curmudgeonly, about ethics in general and ethics training, and for court employees in particular. There's an ethicist in South Dakota named Christopher Bauer who wrote an article just a few months ago called "Why Talking to Employees About Ethics is Usually Pointless." And he argues that there's, when you try to package a training program, there's very little consensus. If we were to do a survey in this room, what is ethics? If there are 50 people in the room, we'd get 50 answers. When you have that lack of consensus, given the nature of the topic, given how hard it is to articulate it, that most of the time packaged training programs in ethics are pointless and we're all wasting our time in this room. I tend not to think so, and Peter doesn't think so either, and maybe you don't either since you're here. But that's, I think, one area where some academics, some practitioners are having some really refreshing discussions, I think, on how do we package these things. It's the fashion to have an ethics code, so all the courts around the country have ethics codes. Relatively recent development, like in the last 15 or 20 years or so. Everybody's got an ethics code now. It doesn't make any bloody difference at all to anybody. Does it increase the level of virtue in an organization? Very debatable. And then we get into interesting topics that I tend to call teeth or no teeth. If an ethics code has no sanction, no enforcement mechanism, does it do any good at all? If you write it as an HR rule, well, then it's not an aspirational ethics code anymore. And for those of us who were involved in writing the new NACM ethics code, relatively new, 2007 or 8, I think, we struggled with some of those. Is this a personnel rule? Is this an ethics code? You have a lot of those struggles. I mentioned those 4 new areas. Something to keep in mind as we go through the rest of this. Some of those same issues might come back as we debate these scenarios and these topics, but we appreciate your time here and hope you use that time well, and hopefully when you walk away you'll think of some of those, and the aspirational purpose that I think is embedded in every code will come through.
Great, thanks. Let me underscore a little bit of a few of Carl's comments in terms of the 2 film clips we just saw. To Kill a Mockingbird premiered in 1962, unbelievably aspirational. Our Chief Justice of the Arizona Supreme Court, our former Chief Justice Thomas Lackett, once said one of the primary reasons why he became a lawyer, became a judge, and eventually became Chief Justice of the Arizona Supreme Court was because of that movie. I have lawyer friends, they've named their kid Atticus, okay? No one's going to name their kid Mickey Holler. I mean, you just know it isn't going to happen. We, over the years, have spent a lot of time trying to respond, I think, to the public's varied and changing perception of our court system. At this conference, we have been talking about drug courts. We've been talking about domestic violence courts. We've been talking about problem-solving courts. And often the comment is that this is responsive to the public's perception. And yet, what was it, 1906, Roscoe Pound talks about the reasons for the popular dissatisfaction for the courts over 100 years ago. And even now, we can see through, if Lincoln Lawyer is any sort of an indication of how people might feel about the courts, because supposedly art reflects society to some degree, it's pretty discouraging. Another aspect to that is when I was going to court administration school, what was the big mantra? It was, justice delayed is justice denied. William Gladstone said that in the 19th century. Chief Justice Warren Burger picks this up. All of us remembered it. A lot of our careers were dedicated to reducing delay, to working on case flow management. And yet, as time has gone on, I honestly don't know. I would ask you to ask yourselves, after all these years, is that the real reason why the public is dissatisfied with the court systems? I don't know. This is still, I don't have an answer for that. I throw this out as I think it's a question that we all have to answer. But Keep in mind the role of the court professional. What do we do? Even in a small way, we represent the courts. One of the things that we're doing in terms of ethics, you've got ethics because they're part of the personnel code, which means you could get in trouble if you violate them. You got ethics because it's the right thing to do. It is intrinsically the right thing to do. And that is very laudable and valuable. I do believe that there is another aspect to that, and that is that we represent the court. We are court professionals. A fair and independent court system is essential to the administration of justice. As, who was it, Mr. Langhorne this morning said, that the courts are part of our heart and soul. I believe that. We, as court professionals, we inspire trust and confidence in the courts, and we convey impartiality, equity, fairness, and integrity. So the rest of the question, the rest of this seminar, think about how we do that, think about how we can do that. But with that now, we're going to have a little fun. So we're going to ask our 3 courageous actors to come to the front of the room. We'll go through the scenario, and then we're going to open up the question and answer for all of you to ask these 3 actors, as their characters, anything you want about the scenario that we're seeing. So take it away, ladies.
Good afternoon. My name is Betty Allen, and I supervise the civil and the family section of the pretty large court. And though I work with parties and attorneys, and I know who the best attorneys are and who isn't, I regularly instruct my staff to be fair and impartial. Staff do not recommend specific attorneys to the public, even when they're asked. My kid's sister, Mary, hi Mary, her and her husband Larry were going through a rough patch, and she let me know that she and Larry were going to be separating and getting a divorce. She told me that she had an appointment the next day with Wendell Wimp-Wright. Well, I know Mr. Wendell Wimp-Wright really doesn't have a very good reputation as an attorney. He caves in, and he ends up losing his shirt for his clients. And he also charges outrageous fees. Well, one night when we were at home and we were having dinner, I said to Betty, you know who you have to go to? Tim Hutton. He is the best attorney in town. He's solid, aggressive, and he charges fair prices. Well, Mary took my advice, and she did pretty well in the divorce. Larry, not so good. Larry, he eats out of tin cans at night, beans, and he lives in an apartment across from the county jail. But hey, I got to look out for my kid sister.
Thanks, Betty. And I'm the kid sister. She's the older sister. Betty and I have always been close, and she's always taken care of me, which I appreciate. Yeah. That's right. And Betty, you're right. She did tell me about Tim Hutton, and I'm really glad she did. I know Betty told me not to tell anybody else, but, my hairdresser, Sophie, is also having trouble with her husband. And you don't get hair like this from any hairstylist. So I also told her about Tim, and that Betty recommended Tim. And I guess Mr. Hutton's business is really picking up. Oh, well.
Hi, my name is Dolores Bates, and I just got divorced. I went to the courthouse, and I asked the gals at the counter, I said, well, who should I get for an attorney? And this dork of a supervisor comes out and gives me the standard bureaucratic BS about we can't advise you on who to hire. And I told her, I called an attorney called Wendell Wimp-Wright, and she just gave me this blank look. I know she was thinking about her shopping order that I took her away from on her computer, I interrupted her. I'm sure that's what she was doing. Well, anyway, my creepy husband, Earl, he ended up with the house. I have both the kids, and I live in an apartment next to the county jail. And so I know it's the job of these public servants to serve me. I'm the public. You should be serving me. It's ridiculous. These government workers to refuse to let good folks like me know who the best attorneys are. I pay their salaries. So anyway, I'm living in my apartment next to the county jail. It's not so bad. I met a nice guy named Larry. He lives there too.
So Betty, you're pretty hard on your staff, making sure that they don't recommend names of attorneys to folks like Dolores when they come up to the counter. You've got a pretty hard line on that. What's the difference with your younger sister Mary? What's up with this?
Well, it's a huge difference. I don't know her. She's not family. I don't know her at all. This is my sister. I got to look out for my sister. Yeah. I mean, if I don't look out for her, she may be living with me, and I don't want that.
So this really isn't about ethics. Really, it's about genealogy. I mean, it's just family, huh?
No, it's more than that. I mean, you know, we may argue and not get along the best, but I still love her.
Mm-hmm. So, Mary, you went over to the hairdressing salon and...
Well, Sophie's like family, too.
Oh, I see.
I mean, I've been going to her for 15 years. She knows everything about me. Trust me. Trust me on that one. And so, I mean, I don't work for the courts.
So you don't really have any particular allegiance to that.
Well, I wouldn't just tell anybody.
Oh, okay. Even though apparently your salon operator told a bunch of other folks too.
Yeah, it kind of sounds like it.
Oh. So.
Betty, now that Dolores is living in that apartment next to the jail with Larry, it's okay.
He was a loser.
Forget about him. You have to move on.
Find somebody else.
How would you explain yourself to Dolores, who's at a serious disadvantage because she doesn't happen to be your sister?
Well, I'm sorry, Dolores, but I don't know you. I didn't know you till you walked up to the counter that day. You know, and that's just the way it is. We cannot give you illegal advice. We cannot tell you which attorneys to hire or not to hire. Maybe you should ask your own sister.
So do you buy that, Dolores?
I don't think it's right. I don't think it's right. You shouldn't be able to tell her something that you can't tell me. I mean, I might as well have just walked down the street and hired just about anybody.
You pretty much did, didn't you?
Yeah, basically. I mean, he had a nice billboard. I thought it looked really nice. I mean, Wimp-Wright, he looked like a good lawyer. And came in, and I could have probably filled out the forms better myself.
But the clue should have been Wimp.
Yeah. Just trying to be fair.
Well, I didn't tell my sister at work. I mean, we were having dinner one evening, opened up a bottle of wine, you know, it's just like, come on, girlfriend.
Oh, wait a minute now. So, again, this isn't ethics, this is geography.
That's right.
If you were at the counter and you're facing
clock.
somebody you don't even know, then the ethics rules apply. If you're at home and then it's okay. So,
yep.
All right. If it's at the counter, all right. If you're out in the hall, is it okay to recommend an attorney? Like, would you tell Dolores if you were in the courthouse hallway?
No, I don't know Dolores at all.
Oh, okay.
And I'm still on the clock if it's at the courthouse hallway.
I see. The Starbucks that's 3 blocks away?
I don't know her.
All right. Just because you don't know her.
Yeah, so I probably wouldn't have told her then either.
Mm-hmm.
Well, if ethics shift with family relationships, how about a cousin involved in divorce?
Well, I got some cousins that are like sisters to me, so yeah, probably.
Mm-hmm.
If you're having dinner and drinking wine.
Yeah, family gets together all the time.
Oh. Do we have any questions from the audience of our 3 characters here? Yes, sir.
Betty, let's say she was your best friend, not your sister. You grew up with her, she's just your best friend. Would you still love her that way?
So if it's your best friend.
Yes, I probably would, because my best friend is like my sister, too. I mean, we go on vacation together. We go to the lake together. I mean, you know, we go out to dinner, too.
Do I need to buy you a bottle of wine? Is that the deal?
Maybe.
I'm trying to hear.
Paul.
How about Dolores having some personal responsibility to do proper research to find the best attorney?
Why do proper research when you can walk up to the counter and everybody knows everybody?
But we don't tell you that. That's why you should research it.
Well, you know everybody that's in the courthouse. You know who's reputable and who isn't.
I don't know you.
I shouldn't have to do that when you already know.
So, any other questions of our three characters? Okay, well, thank you very much.
Thank you.
Oh, we have one? Did we have a question? Sorry, I didn't see it. Go ahead.
I guess I was just going to make a comment. I mean, you're taking Betty's word for it, but she could have been steering you wrong, too, because you truly don't know.
Betty would tell me the truth.
Well, yes.
She knew well what she knew anyway from her experience. Yeah,
It's her opinion.
It
I mean,
is.
It could turn out that the guy was a jerk, too.
Mm-hmm.
So you saved yourself.
Maybe. Sure. Yes, ma'am.
No, I have a question for Betty also in terms of her role as being kind of fair and impartial and not taking sides, whether it's one party or another, or one lawyer or another. So does that matter?
Well, yes, it does. But again, I wasn't at work when I was giving this advice. I was at home with my family having dinner. And so, it would be the same if my husband asked me, if what attorney to go to, for his business. I'd probably suggest what attorney for him to go see also.
Betty, you're a supervisor. Would you tell your employees that they can do the same thing?
Oh, no, I would not tell them that.
You'd expect them to know that those standards about not recommending attorneys only apply in the office and only apply to strangers.
No, I probably would just tell them that it was unethical to do this at the office, and that is it. If they asked me if it was after hours, well, I'd probably have to call the district office and ask them.
Okay. If you caught one of your employees, say you were standing in line at Starbucks, and one of your employees started recommending Tim Hutton to somebody you don't know who it is, would you call your employee on it?
Yes, I probably would.
Okay. So but do you think that there's a double standard?
I'm
here?
also there at that time, and I'm overhearing it. So, at Starbucks and.
Okay. So it's just happenstance and chance of whether one of your employees might get in trouble.
Yeah, I would question my employee.
Mm-hmm. Okay.
Danny, what if your husband went and told his best friend who he should go see an attorney because his wife that works at the court administrator's office told him?
Well, he would be in big trouble. So he would not do that.
Oh, okay.
So, yes, sir.
Let's keep the circle going, Betty. Let's say that the hairdresser's sister has a daughter that works in your office. And so the hairdresser mentions that to the sister, mentions the daughter, your employee, comes and confronts you with it. How would you respond?
Well, I'd probably investigate further.
Upon further review.
See if she had her facts right. What witnesses?
Outstanding. Paul.
What was Betty getting involved? Does she not have the right to make her own evaluation as to the best attorney to serve her needs at based on her experience?
Does she have a right to do that?
For herself.
Uh-huh. Well, yeah, she seems to have
Is that
that.
an ethical dilemma?
Well, I would ask you, if Betty herself was getting divorced, and she works in the court, so as frankly, a lot of us, let's be honest, we do know who the better attorneys are. If you work in family court, you know who the better family court attorneys are, and ones you probably would stay away from. If you're going to get divorced, I think you end up with special knowledge. Are you allowed to relate it to other people? You can't but help, you're not going to automatically go to Wendell Wimpright if you know he isn't any good. Yes, ma'am.
So Betty's getting this divorce, and she wants to hire Tim.
Mm-hmm.
But Tim's feeling pretty grateful to Betty right about now because, he's picked up a few clients.
Yeah.
What if he cuts his rates for her?
Sounds good to me.
There was another question? Yes, ma'am.
Well, I was just wondering if everybody looked at the courthouse, if the judge was aware that this was
Yeah, I mean, that actually gets into a separate issue, and we actually deal with this later in the day in terms of notifying the court when you have a relative. John?
Peter, I was clerk of the bankruptcy court in New Mexico. I left there in 1996. And a friend came to me a couple of weeks ago and said, I have a friend who is going into a bankruptcy. Would you recommend a lawyer? What about that court relationship that ended in 1996? Am I ethically barred today? I have no question about the impropriety,
Of this particular situation.
but I'm wondering whether I still have an ethical obligation so many years after.
With information that's stale now by 15 years, at what point in time does the level of your wisdom and knowledge and the inner workings of a court pretty much just relate back to that of a normal citizen? After 15 years, well, let me ask you, John, do you think at this point in time, 15 years later, do you still think you have special knowledge?
Yeah.
You still, well, yeah, but because of what you did or because of your consulting operation that you have held? You still think you still have special knowledge? You still could, even to this day, would be able to pick out the better attorneys?
Of course, they don't change their spots.
Well, I would expect then that you're answering your own question. What do you think, John? Is the fact that as long as you have special knowledge, I mean, you have something special that you are imparting, which makes it very difficult.
Well, what would you do with Paul's question, John, about your own attorney selection? I mean, you can't unknow something.
You can't unring the bell. So, I mean, I think just for practical purposes, you deal with the knowledge that you have. You're going to go to Tim Hutton. Yeah.
So it's okay to use it for yourself. Or you just can't. If my brother gets arrested for DWI at 3 o'clock.
Yeah.
Okay.
Yeah, I think that we get into a whole new area here. It's just what can you share with other people and under what circumstances. So, what other questions or comments do we have from these folks? Oh, we do want to applaud you. Thank you.
Yeah. Thank you.
Please remember that they are actors. I think we were in Pennsylvania once, and we actually had the court administrator up. It was a scenario similar to that, and it wasn't the presiding judge, but it was one of the judges in the back room, and the judge just started laying into the court administrator, and I had to stop it. And I said, "He's acting, Your Honor. It's not what he really thinks." So Carl, let's hear about the codes.
I mentioned at the beginning that there's a significant amount of debate lately about whether codes really help, whether they have any point. Because of shades of gray, because of the clash between theory and articulate English and real life, that codes, even when they're very well written, have very little practical, are of little practical help. I think that's a useful discussion. I tend to think they do have a practical value, and of course Peter and I do too. But Peter does too. But it's maybe a more remote value. I mean, we tend to think it's aspirational. It instills this sounds a little To Kill a Mockingbird closing argument idealistic, but I think it really does increase the level of nobility among court employees. And I talked about that sense of identity, and I think codes help encourage that higher, more noble, more ethical, ultimately, sense of identity among court employees. So I think it does have a practical value. But let's go through some of the codes. some of the examples of attempts to deal with situations like this and see what they say, to see if it's any help. Let me pick Minnesota first. I won't read every word to you of all these. Article 1, abusive position and conflict of interest. Employees shall act so they are not unduly affected. This time around when we were doing prep, for the first time, that phrase unduly affected really jumped out at me. There's a provision there, there's room there to acknowledge that there's some influence, some effect in family relationships that employees are going to find difficult, if not impossible, to set aside. When your brother is arrested at 3 o'clock in the morning and he picks up the phone and calls you from the jail and asks, who's the good criminal attorney to get me out of this or to help me through this, I wonder how many would say, I'm not going to tell him.
That's exactly what I was thinking the whole time this was going on.
That when the call comes at 3 o'clock in the morning,
Yep.
right, go ahead.
I really wonder what I would do, because I can, I'm in criminal court, and the scenario that runs through your mind is people are going to ask you who the good DWI attorneys are, because that's such a popular, common crime.
Well, here, let's do this. In the morning session, Peter mentioned that it was like 50-50. That when we survey rooms, it's who's going to serve up the attorney recommendation to a member of the family and who's not. I think it's a little easier for Betty to be evasive with her sister in our scenario that we just did, maybe. Let's try another one. When your brother calls at 3 o'clock in the morning and he's in jail and he needs a defense attorney right now to give him advice on as to whether or not to take that breath test, how many would give your brother the standing at the counter court employee answer? John, okay. Well, John and Paul. All right. That's it? So much for your 50-50.
Yeah. It's a tough crowd.
Who would tell the brother where to go? I mean, where to... There you go. Boy, that's not 50-50 at all.
No.
See, I tend to think that...
I'm reassessing my statistical analysis.
I think that's the more honest, practical, accurate answer. Paul?
Just explain a little bit. I would adhere to the policy, except for my kids. That would be the one exception that I make. Siblings, parents. No, I love the rest of my family, but what if it came out wrong for them? I mean, what if they ended up in jail?
Can we spend a minute on this and tell me, describe what that conversation would be with your brother? He's on the phone, it's just one phone call, it's 3 o'clock in the morning, he just woke you up, and he needs to know, what do I do, how do I get out of this? What do you tell him?
I would say call the attorney helpline, or we have a service lawyer number. I would not give them the name of an attorney.
Child is different? Well, you see how it's a little hard to rationalize or justify that distinction. I mean, that you happen to make, but others might not.
No, but I'm probably going to be in court with my kid. I'm not going to be anywhere near my brother if he's in court.
Well, I was going to say, a child to me, I mean, she just turned 17, so I would be the one hiring the attorney. So
Okay.
there is a distinction there between giving advice to somebody versus, again, what we were talking about earlier, using your own knowledge for your own benefit, because it is your benefit in addition to your child, in my mind.
Bridget?
This is a scenario that always kind of confuses me, along with the not giving legal advice, because I am an attorney. I am a licensed attorney, and my family calls me, and so it's always a difficult situation to be in because I have different codes that I have to deal with. And one is more obviously important because it's the one I've worked under, but it's also the one that I'm licensed under. And I don't do legal work anymore, but there's always that, oh my God, which code is it that I'm supposed to be dealing with? I get, at 2 in the morning, I'm not going to remember.
Do you make
is this the bar, or is this?
Do you make the same distinctions Paul does about how your ethics function depending on where you are in the family tree?
I probably would do a little more investigating and give my own advice of, you have to do what you need to do, but there's numbers you can call, or
Yeah.
My family would call me and say, can you give me the phone number of so-and-so because I don't have my cell phone or whatever.
Mm-hmm.
And then that's the question of, can I give them the phone number when they ask for the specific attorney?
When Carl was referring to the show of hands, we have done this scenario at various events around the country, and with maybe the exception of this group, it seems to come out more and more about, or it seems to be about half and half. Half the group in any setting would say, no, I am not going to be giving that out. I don't give it out at the counter. I don't give it out at Starbucks. I don't give it out to anybody. The other half say, and when you're talking about two different codes, I think it was Thomas Jefferson who said, we have a variety of ethics codes. We may not know that we are abiding by an ethics code, but one of those ethics codes that about half of the group says, family comes first. I don't care. Whatever the ethics codes, that's fine. But family comes first. And about half of the groups, except for here, will say that. And you have to respect that. I mean, you know, whether that's a defined written code or very well articulated or not, it's an ethics code in and of itself. Kathy?
You know, how about our colleagues that call us up and ask us for the name of an attorney?
Mm-hmm.
And they both know the code, or both know the code. How is that, you know?
Well, yeah, I mean, even Betty was saying, well, yeah, it's family, or it's family and good friends. It's people who I think are family. I mean, as that scenario was going, Betty's definition of family was expanding. Did you notice that? I mean, it was becoming a real Italian family.
We need to probably move on to the second one, but let me go through just some of these really quickly to wrap up, to give you a sense of how different codes in different states deal with this sort of issue. Minnesota's policy on abusive position and conflict of interest would sort of go to your considerations about legal advice, because you happen to be an attorney. The National Association for Court Management came out with a new code relatively recently, about 2007. And this is what their code says. Uses the same phrase about unduly affected. Introduces a huge amount of gray in there as to what unduly means. And then the American Judicature Society, this is a really old resource. It came out in 1989. It's still published on the AJS website. I think it's still really useful. The fact that it's lasted and is still referred to so long, and that we used it when we wrote the latest NACM code as a really solid, good reference, I think it sort of demonstrates that how well written it was and well considered it was back in '89. But that's what the American Judicature Society's model code says. And then we go back again to legal advice. Okay. We might have addressed that.
I think we've addressed most of those, so I think probably we're going to move on to the next scenario, which is a video. Please work.
Hello?
Hey, Dan, can you come pick me up?
Dale? Where are you?
Kind of at the police station.
What happened?
Just get down there, I'll explain it all. It wasn't my fault, really. Oh, and Dan, can you bring some money?
All right, man, phone call's over.
Like about $1,000? Cash?
How the hell did you get popped anyway for possession?
Like I said, it wasn't my fault. I had a single joint in the back seat. One joint. That guy I was with, Eddie, we were hanging out at the birdcage having a good time. Turns out he had cocaine on him. I didn't know. You gotta believe me.
Man, I'll take you home, man, but, you know, come Monday, you gotta tell Phil. You gotta tell him the whole story.
No, I can't tell Phil, man. Look, you and I go way back. You're my supervisor and all, but you were no angel back in high school either, and I got you out of some pretty tight jams back. You owe me this one. I can't tell anybody about this.
Oh, man. You know, we both work at the court, man. We work at the court. They're going to find out. You know, I mean, geez, I'm your supervisor and all, but I'm still on my probationary period, man. I could lose my job, too.
All right. Just give me some time. I'll do it. I just got to figure out how to tell Phil without him spazzing out on me. It's got to be the right time, okay? You owe me at least that much.
All right, bro. You got it. So what did Phil say after you told him?
I go and see him later today. I got an appointment to talk to him.
It's Wednesday, man. How long are we going to wait on this thing?
I'm doing it, okay? Judge Williams has me hopping right now. I just haven't had any time to do it. Don't worry. Besides, they filed in a justice court anyway, so there's really no rush.
I got a call from Judge Anders today. He had lunch yesterday with an old pal of his, a police detective. Apparently, Judge Anders took quite the ribbing over one of our court's own being arrested for possession. When exactly were you planning on telling me this little tidbit of information, Dan? Dale's gone. I terminated him this morning, not for possession, for not telling me. You're on probation, Dan. So you can kiss your supervisor position goodbye.
Look, Mr. King, I thought that I was following the proper protocol. It's a court employee that's supposed to go tell HR. And I thought that he had made that appointment to talk to you and to do it. I thought I was doing what I was supposed to do.
Don't give me that, Loda. You had an ethical obligation to notify a superior at your earliest convenience. You're going to be back in my office tomorrow after I've had some time to think about what I want to do.
Mr. King, I hate to interrupt, but I don't mean to be funny and all, but why was Judge Anders having lunch with a police detective? I mean, you know, Judge Anders, he's a criminal judge, and police detectives are called on the stand on a regular basis.
I'll see you tomorrow.
I want Peter's production studio in Maricopa. Let's go over some of the codes.
It's much less impressive than you think, believe me. That was my own car they were sitting in. So. Yes, ma'am.
I have a question.
Sure.
Regarding, say that you've got employees at the senior court level and whatever, and one employee knows that the other employee got into trouble on the weekend and whatever, got arrested, and that employee, she was encouraging the other employee to go in and talk to the supervisor and didn't and whatever. Is there some responsibility on that brand?
Well, here, let me ask, do you think ethical expectations and duties shift depending on where your box is on the org chart?
But I mean, if there's at the same level,
So, I mean, so you think there's a difference there?
that's the thing. I mean, they're not in a supervisory position. They would have been a supervisory, then they would have the obligation. But if they're at,
A lot of us are court managers and court supervisors in this room. So we may be. It's hard not to answer this in a self-interested or oh, sorry. The question is, if they were coworkers instead of supervisor or subordinate, would that change what the obligations are?
Well, let me ask, how many of you think that you have a coworker who you, and I'm going to change the scenario a little bit, that you have very solid information, not just a rumor, but solid information that one of your coworkers has been arrested, and you're not particularly involved, but you feel an obligation. I would expect that you have you feel some obligation. How many of you would take the initiative to go to your supervisor and relate what you know? Only about half. How many wouldn't?
If you change that to charged, my hand would go up. Yeah.
Okay.
Talking about peers as coworkers?
A peer, yes, not somebody who's reporting to you, but a coworker. Okay, charged. You wouldn't do it if they were arrested, though.
I would.
Mm-hmm. Why not?
Because there's a difference between arrested and charged.
Mm-hmm. What's the difference?
Well, the interface with BCA.
Minnesota policy doesn't seem to have much of a difference.
No, but
they talk about arrests.
No, but how it's going to affect me does.
Uh-huh. How does it? Oh, go ahead. Go ahead.
How would you know whether they reported it to their superior? You wouldn't. I mean, you'd be jumping in, assuming that you didn't do what was right. You have no idea if they didn't report it like they should have in the first place.
This is a very a difficult situation. You go ahead and report, and then, of course, you could be a rat. You've ratted somebody out. And, of course, I changed the scenario to say that you have very solid information. Most of us, of course, we know that in real life, you don't have very solid information. Somebody told you. Somebody told them to tell you. And so you're already working with secondhand, sometimes third-hand information, and you're faced with this dilemma. But if you hold back and it comes out that you knew 3 weeks or a month and a half ago, and then somebody's going to say, and you didn't come forward?
We don't have a judicial code of ethics in the state of Washington, so we have to, at the local level, work through our HR codes of ethics and also the judicial code of ethics to try and make them marry up and match up. But when I read this, and I'm looking at it very literally, the thing that's going to actually get you in trouble here is the fact that you didn't disclose the person. Right. I'm the person who got arrested this weekend. The duty falls on me. The duty of my supervisor, my manager, and up the chain is to educate me about my duty here. And also to explain, I need you to disclose that you got a negligent driving ticket, even though it's going over to the district court. The district court in Washington may want to send it to the local municipal court so there'd be no appearance of special treatment. You're probably not going to lose your job because you got a neg driving. But you're right, it's the amount of time you know something. And certainly peer-to-peer, you'd want to be supportive of your peer and say, really, if you want me to go with you when you do this, I'll do that with you. I'll help you get through this. But, again, it's education around what the duties are that's really important here and what the outcomes may or may not be.
So Dan was doing the right thing? Mr. King should have backed off.
Well,
Dan was in the right. Is that what I'm hearing?
I'm not saying that at all.
So the supervisor should have been able to depend on his subordinate and his friend.
Well, there's a little more information. I'm talking peer-to-peer.
Okay.
Right, that was
okay.
I'm not so sure unless I've been educated on that duty. Am I a mandatory reporter? I don't know. As a supervisor, I'm betting I am a mandatory reporter. And if my employee wasn't going to go with me, I would have had to say, I'm so sorry, but we're going right now, and if you're not going with me, I'm going in there by myself.
This is a really interesting angle on this that I don't think I've quite heard before, and it relates to that sort of formalized status. Do you need that formal mandatory reporter designation to rat them out?
What a great turn of phrase.
It depends on how have you been educated on people like this, you're going to get as many answers in this room as you've got today. But if you're truly educating around this code, you're really breaking it down and saying, you know, you and your husband get into it over the weekend, and the Lacey Police Department comes over. Maybe they don't arrest anybody, but if, you know, the buzz is out there that, you know, you and I had a little dust up this weekend, or maybe you got arrested and I didn't. It's really interesting.
Any comment on
back there.
any response? Oh, sorry.
Oh, can you sort of? She's got the microphone there. Yeah.
Oh, yeah. Thanks.
So when people want to talk.
Yeah, this is the recorded session, so I'm sure we're driving the recorder tech nuts. But let me spend a little time on that and reverse the roles. If you're the presiding judge or the court administrator, if you're the box at the top of the pyramid, and one of your employees has shaky information, but it's information that a coworker did something bad, do you want to know?
I do.
Whether the information's shaky or not?
Correct.
Whether it's formalized or not?
Correct.
Okay. And would, if you were at the top of the pyramid, would you want to know it?
I don't. I want to know if it really happened. And I want to know this way, or if that person went to their supervisor, I think the supervisor has a duty to report. I think the supervisor in this scenario was wrong.
So when you find out about that felony charge in a jurisdiction in the next county, and she didn't tell you, that's okay.
But how, I don't know who knew.
Okay.
Yeah.
Interesting. Interesting.
And here, all the employees are required to sign off every year that they know this policy.
Okay.
So there isn't a willy-nilly or haphazard manner of distributing what the employees should do. They know. They signed off that they knew. They know about this policy. It's not buried in some book somewhere.
Andra?
But if I'm reading this literally, I would not, as a peer, have to report a peer. I mean, it's really just the employee. It's just so, hey, I don't have to report right about. Doesn't even say a supervisor.
Does anybody here think it defames somebody if there's some gossip that somebody was busted with cocaine and there's a bunch of whispering that, you know, Brenda got busted with cocaine over the weekend and, oh, I guess she didn't? Doesn't it?
Oh yeah, I think I can see that. But I mean, it's the tightrope. You don't want to defame, but on the other hand, from a very selfish point of view, I don't want it to come out a month and a half later that she really did get busted, and I knew, and I didn't tell a soul.
But did you know, or did you just hear it?
Well, I mean, yeah, I can weasel out of stuff like that, but I mean, I would know. I mean, if I had fairly solid information. Well, that goes to another question of how solid do you need it? I mean, do you need to actually have been there? If somebody you really respected told you, second, somebody who told them who told you, so you're now 2 times removed at some point, yeah, I don't really know it.
Paul?
Does it make a difference? Thank you. Should I sing? Does it make a difference what you heard they were charged with? And I'm thinking something like the individual was the bookkeeper at her church, and you found out she's been stealing money and she was arrested for that. Now that applies directly to her work, perhaps. So is there a chance she's also stealing money in the office? Does that make a difference?
How so? How does it make a difference?
I think it makes a difference because that implies that there's been some investigation and that the charges are probably pending, and I do think it affects their job directly.
Yeah.
It might be a little bit different than something that's 3 o'clock in the morning and you maybe don't have the blood alcohol test results back yet, something like that. Maybe doesn't necessarily impact their job as much. I think the charges do, in my situation on how I would handle it with a peer, I think the charges would, it would matter to me how I handled it.
Yeah.
Are you comfortable at all with feeding shaky information up the org chart and whoever's at the top of the box, whether it's the PJ or the court administrator, can weigh it for what it's worth, and you leave the handling of it to that person's discretion, that doesn't cut it.
Well, I think that's tough. That's a tough one. But I do think that as an administrator, you want to get in front of it no matter what it is. So that's a tough one. But it's pretty clear the duty to report isn't there. But it would depend on so many factors as a peer, whether you're comfortable with that. Maybe you're comfortable with your boss, or how you think your boss is going to handle it. But as an administrator, I want to get out in front of it right away.
Yeah. Yeah.
Let me ask one other question. Does it make a difference if this occurred and to some extent it occurred in a court of a different level in this scenario, but does it make a difference if it occurs outside your jurisdiction? I mean, Sioux Falls happens to be 15 minutes from the Minnesota border. If somebody goes to Laverne, Minnesota, Rock County, and popped for DWI, we had a long debate about whether we cared. Do you care? Okay. So where it occurs doesn't. Okay. John?
I'm sure that since you've done this before, you've had this question before. Why is the arrest the critical thing? What if I know that Paul regularly uses cocaine? But he's never been busted for it. That's the trick.
I mean, I have an answer. Anybody want to answer that one? I know I have an answer. We do a perp walk. Kello TV puts a camera in a little window in the hallway between the jail and our arraignment courtroom every day, and I don't want a court employee on Kello in the afternoon. That's my answer. I want to know about the arrest because I'd sure rather learn about it ahead of time, get ahead of it, than Peter's situation where I find out a month and a half later. Even an arrest, even if it's ultimately dismissed, I don't want a court clerk.
Well, I think I know where you're going, and I have to say, I'll just give my own opinion on this, I think that raises a very practical issue. And the practical issue is, an arrest is a documented event. You may know it, you could do some research, maybe what you do is you tell the court administrator, I heard that so-and-so got popped this weekend. I don't have any validation of it, but I just thought you'd want to know. Now I've done my job. Now I've told you can do whatever you want with this information, Mr. Court Administrator, that's fine. When you're getting into, I think that Pete Kiefer snorts coke. Well, okay. How do you then it comes back, John, how do you know Paul snorts coke? What, are you snorting with him? I would have an increasingly difficult time being able to know and not finding out why I know. Yeah, I sold it to Paul, So, I'm in my mind, I'm having a very difficult time trying to conjure up a scenario as you're proposing where I know, and yet I'm not actively assisting in the process. Or whether I got basically just a bunch of gossip. And with a single event like a conviction, like an arrest, yeah. we'd have to chat about some sort of a scenario, which I would be happy to put on video, where somebody would be able to have solid information and yet not be actively involved at the same time. I can't think of it myself.
Boy, it's just fascinating. I just love this topic and one of the reasons I love it is no matter how many times we do this, no matter how many times we play these scenarios, new angles and new issues always come up, like this discussion about formalization and the validity and the reliability of information fed up that org chart.
Let's have a couple more comments and then we're going to have to move on. Yes, ma'am.
The scenario that I have not personally been part of, but I know of, is of being witnessed of it. 2 employees, somebody went behind this is in a factory environment, so it's talking about safety and whatever else.
Uh-huh.
They're behind a machine and smoke pot. Well, that other employee did report them. So that is a scenario that this person would for sure know, possibly.
Yeah, I guess. I mean, you walk into the men's room and here he is with a needle in his arm, I guess. I don't know. So, yes, ma'am.
Getting back to the theft situation, I guess I would want to report that just to protect myself. Because obviously when money is missing from the office,
Everyone could potentially be, that's for your own self-protection. Yeah. John?
I just want to recount to you quickly a situation in Albuquerque, New Mexico. The chief judge of the district court had been chief judge for 14 years, highly respected judge, arrested for driving under intoxication with cocaine all over himself and a woman, not his wife, sitting in the seat beside him. The court system of New Mexico has not, this happened 10 years ago, has not recovered from that event.
Yeah.
The gross hypocrisy that it represents. Now, if his his administrative assistant knew that he was using cocaine and cheating on his wife, doesn't that administrative assistant have some responsibility, or just say, I'm the court administrator there, and I know he has this habit. Don't I have some duty to the court system and to him?
Oh, personally? Yes, absolutely. Uh-huh.
To take some action?
Yeah. No, I completely agree with that. I can certainly see that and the devastating effect that it would have. Okay. We're going to have to move on.
Yeah, we do have to move on, but I want to go, I'll touch on these just really quickly. The NACM code is in that little red booklet we all got. That provision opens up, it has a significant effect on our discussion and what our obligations are if we impose that on ourselves. Of course, model code's a model code, it's a model. So whether the degree to which we impose it on ourselves, I'm not sure, but I think at one point during the teleconferences about this code, somebody nicknamed it the rat code or the rat provision. But, yeah, interesting topic. I mean, we could go on for a while, but we really do have to move. And the American Judicature Society's model code says pretty much the same thing. And we kind of covered those.
Yeah.
You know, John, to follow up on your comment about what was the right thing to do, you know, one of the I have, and a lot of us probably have, when we do this ethics stuff, we have some tests when we're struggling with one of these situations. How would it look on the front page of the paper? If I were in that position, what would I think the right thing to do would be? One that I'm using more and more often and discarding the others is, what should the public be able to expect? What's in the best public interest? You know, set aside my brother at 3 o'clock in the morning. When Dolores walks into the courthouse or a member of the public, what do they have a right to expect? What would have served the public best? And I think the answer to that one is, it would have served the public best to address that problem with the court system before it occurred the way it did and did such long-lasting damage. Well, anyway, next scenario.
Here's your mail from last Friday, Mr. King. Did you have a good weekend?
Yeah, it was okay. How was yours?
I had a wonderful weekend. I got friended by a very nice gentleman on Facebook who lives in San Diego. He wants to take me on his yacht.
Oh, very nice, very nice. Should be fun.
So are you upset with Kathy Court? I thought employees weren't supposed to badmouth the court on the web.
What?
Yeah, Kathy has really been ripping the court on her Facebook page.
No way. Let me see.
Here it is. BK at it again. He thinks he is lord of all he surveys. Another good person has left this court thanks to his handiwork. So, BK, Bob King, you had to let Phyllis go last week. Phyllis and Kathy were very close.
I'm going to put a stop to this right away. Carol, get me that IT guy on the phone right now.
You mean Carl?
Yeah, Carl. Get him on the phone.
Hey, Mr. King.
Hey, Carl, thanks for coming by on such short notice. I really need you to look at some web usage by one of our staff.
Okay, what's his name?
No, it's not really a him, it's a her. It's Kathy Korn, last name spelled with a K.
So you need a log of her court email traffic?
Well, that's not exactly it. What I'm really looking for is her activity on social networking sites like Facebook, LinkedIn, Twitter, MySpace. She's been making some real disparaging remarks about the court. And if that's true, it's got to stop, and now.
Got it. Well, I can't go back and see stuff that she may have already removed, but I can definitely monitor going forward.
Great. Get back to me as soon as you can.
Will do.
Morning.
Carl stopped by. He brought you the results of your research project.
Finally. It's been 3 months. You should have something on that corn lady by now. Kathy, this is a compendium of your Facebook entries over the last 3 months discussing the court.
What?
Do you have any idea how unethical it is to make statements on Facebook about the court, disparaging the court?
But I didn't say anything.
Let me give you a few examples. The work here is mind-numbing. My brain is slowly turning into mush. I feel so much contempt for these stupid people in foreclosures getting judgments against themselves for their credit card debts. This is not the Facebook entry of an unbiased representative of the court. Or how about this? BK is at it again. So many people have been hurt by the way he acts, and he doesn't even seem to know or care. Kathy, I do care. I care deeply about every one of my employees.
Well, but
Ms. Korn, I want you back in my office on Monday morning, and I want all of those entries disparaging the court off of the page. See you Monday morning.
Mr. King, I'd like to introduce you to my attorney, Mrs. Laura Templeton.
Mr. King, as Ms. Korn's representative in a possible employee action, I was just wanting to ask you a couple of clarification questions.
I'm going to have to get our court counsel in here. Carol? Carol? Hey, can you get Bill Williams in here right away?
Can't. Today is Mr. Williams' flex day, Mr. King.
Okay, fine. What questions do you have, Ms. Templeton?
Does the court have a social media policy? I was wondering if you could get me a copy of the policy on monitoring employees' use of networking sites. I tried to find it on my own, but I'm sure I just missed it.
We're actually working on that policy right now.
I also took the opportunity to call Carl Bittner, the IT support center tech. I asked Carl if he had an accounting of the staff time devoted to monitoring employees' use of social networking sites over the last 3 months. Will you please provide this information to me?
What did Carl say?
The point is, I will find this information out, even if I have to get a judge to order you and Mr. Bittner to tell me what it is. Probably the most important question I have for you right now, Mr. King, is if you can share the specific basis for your decision to monitor my client's Facebook page.
I'm not really prepared to discuss that right now. I'm going to have to talk over with county counsel.
By the way, Mr. King, I know in your discussion with my client last week, you were very concerned with references my client made on Facebook to BK. You do realize that my client has a brother named Brian Korn. His initials are BK.
Maybe we can come to an understanding. Maybe Ms. Korn did nothing unethical. I would really appreciate it if she could remove those entries from her Facebook page, especially considering our upcoming policy on social networking for the court.
Well, if you would be willing to include the fact that my client did nothing unethical in her next employee evaluation, which happens to be at the end of the month.
Yes, okay, yes.
Great. Well, I think our business with Mr. King is concluded.
I have to ask, BK? Of course it was King. He's the biggest jerk in 3 states.
So let's review some of the codes really quickly. Well, before we do that, any reaction? Okay. Release of news information. A lot of states have a provision like this where they protect political activity. South Dakota has one that says, it's very expansive. It says nothing in any personnel rule for any branch of government should be construed to inhibit the First Amendment and other constitutional rights enjoyed by any citizen in South Dakota. And so, the judicial branch will assert certain restrictions and cautions, but and it's never been tested in our jurisdiction. I don't know. I think it has been tested in Minnesota when one of the court administrators actually tried to run for office. I can't recall how that came out. Does somebody remember? I don't know if it's been tested. But anyway, so a lot of states do have these provisions. Try that one. So do Facebook postings at 7 o'clock at night about, boy, what a terrible day I had at the office. Does that adversely affect or adversely reflect? How about that judge is a real jerk? Okay. And the NACM model code, court professionals shall avoid activities that would impugn the dignity of the court. A little earlier when we started, I talked about phrases like impugn the dignity of the court and those identity issues about how court employees see themselves. Do we have an identity as a court employee first? Is that secondary? Is it a way to pay the mortgage? Is it more than that? Is it intrinsically different from a job stocking at Sam's Club? I tend to think it is. Peter probably tends to think it is. I think probably most of us tend to think it is intrinsically different, and we can be held to a higher standard. But I think one of the things we run into, and most of us have probably recognized it, is the common understanding or assumptions behind that phrase, impugn the dignity of the court, are far more difficult to identify and far less a matter of broad consensus. And finally, a court professional shall be respectful of litigants. And, of course, our comments about dumb people who come in here and get judgments against them would run pretty clearly counter to that. This is NACM's. We struggled with how to address the internet. It's such chaos. There's solid information out there. There's flimsy, weak information out there. There's everything in the spectrum is floating around out there on the net. And so we struggled with: do we Google court employees, or prospective court employees, or current court employees? If we find out that the judges are the employees are Googling judges' personal life stuff or our personal life stuff, is that okay? Should we expect that? We struggled with it for a long time, and finally we came to a conclusion, I think, that is the most useful and practical, really, under the chaos that the internet can be, and that's just sort of a discretion standard. We're going to get terrible information. We're going to get solid, highly formalized information, actionable information, so to speak. And then we have to use appropriate discretion on how we handle it. And there's the AJS code from quite a while ago, but I think it still's got some value. Mm-hmm. Okay, questions?
Yeah, we're pretty tight on time here, so let's just ask one question of your opinion. When we're working on an article now about different age groups, Generation X, Generation Y, and baby boomers, and how they look at the social network. This is one aspect that we've been looking at. And it is fascinating the difference in opinion. Baby boomers, pretty much 85, I think, or 90% said the court has every right to go on Facebook and MySpace and Twitter and be looking at court employees and looking at candidates for court jobs. With the Generation Y, I think it's like 40% say the court has no business going on Facebook and looking at what I've got posted. Facebook is a social medium, and my work is my work, and the two are separate. So I'm fascinated. How many folks think that it might be inappropriate for the court to be looking on Facebook for employees, for what we were seeing, or for candidates? Anybody? Really? Why do you think it's inappropriate?
You know, I really wish I could give you a great answer to that. It just makes my toes curl.
Mm-hmm.
Because if I'm hiring you, I should be doing a full review of your qualifications.
Yeah.
And I should be talking to your references.
Mm-hmm.
And I should be listening to my visual voice. But it just curls my toes. That's all I can tell you.
Mm-hmm. Okay. Alrighty. I think we're going to have to wrap it up. You will notice one thing, this upsets some folks, but Carl and I adhere to it. We don't stand up here and give you the right answer. We feel it's very strongly that you have to come up with the right answers to these questions yourself. You have to make this internal, because what we feel about codes of ethics is it's not just right or wrong answers, but it's an aspirational tool to impart trust and confidence in the public. On a very practical level, what I would recommend is that what we're trying to achieve are 3 levels. The first level, which is the okay level, is your employees say, I'm doing this because my boss tells me to do this. Or, I'm doing this because the code of conduct says I've got to do it. Okay, I mean, they're doing it, so I guess that's good. Better, I'm doing this because the code of conduct in my court says I've got to do it, and I understand the reason why the code says this. So not only are they doing it because they've got to do it, but they do it because they understand it. Better. Best, I'm doing it because the code of conduct in my court says I got to do it. I understand the reason why the code says that, and I agree and support that reason because I'm a court professional. I think that's what we need to be striving for in the court, is not just compliance, but also commitment to it. So with that, thank you very much. We had a lot of fun. It was great. Thanks.
Thanks.